Now, once the CIRP proceedings are initiated, the IRP is to give a public announcement in 2 newspapers, one in local language, inviting claims from all the creditors of the corporate debtor. So any person, any creditor who claims any amount from the corporate debtor is required to submit its claim with the IRP RP within a period of 14 days from the CIRP commencement date or from the date of publication. However, a creditor who fails to submit the claim within 14 days may submit the claim to the IRP RP on or before the 90th day of the CIRP commencement date. So if the claim is not filed within 90 days, the only option available to the creditor is to file an application with the adjudicating authority seeking condonation of delay in filing the claim. And now the Supreme Court has made it very clear that in case a creditor fails to file the claim and a resolution plan gets approved, then that creditor will lose its right to file the claim at any subsequent date. Now the resolution plan which we have been talking about will be based on the claims received by the insolvency resolution professional, because it will be the claims on the basis of which resolution plans will be drawn up. The claims will decide the liability of the corporate debtor. So suppose a person has not claimed, especially in case of real estate, we have seen that a lot of people fail to file their claims with the RPs when a builder goes under insolvency. Either they are not literate enough to know that the corporate debtor or the company or the builder is going under insolvency, and at many times the people are not even India. Especially builders, they have sold units all over India, and CIRP proceedings starts. The publication is made, especially in Noida or Gurgaon or Delhi, if we are talking about NCR. So a lot of cases are there where people have failed to file their claims. And subsequently, when the resolution plans get approved, the resolution applicant who is taking over the control and management of the company, he relinquishes the claim. He treats the flat given to a particular individual who has not filed the claim as a free unit belonging to the corporate debtor. And it results in a lot of litigation and harassment to the individual creditor or the home buyer at a later stage. So everyone must be aware of where the projects are delayed in India, especially in NCR. The home buyer must keep a track, the unit buyer must keep a track. The moment the corporate debtor is admitted, especially Supertech was admitted under CIRP proceedings. So Supertech is having a lot of exposure towards individual unit holders. So everyone must file its claim with the IRP or RP within the period of 90 days. Without filing of claim, you may have a lot of documents in your favor. You might be having agreement to sell, payment receipts, but once the resolution plan will be approved, everything will be of no use. So the claims are a must, because on the basis of these claims, the COC will be formed. Now, once the claims are received by the IRP will constitute the committee of creditors comprising of all the financial creditors of the CD. The voting share of such members shall be determined on the basis of financial debt owed to them. So this is again a departure from the Companies Act. It's not the voting right is given on the basis of claim amount, the admitted claim amount. So the total admitted claim amount will be taken as 100, and the claimants, the creditors, financial creditors will be given their voting percentage based on their admitted claims. So suppose there are 2 financial creditors, one has given a claim of 50 lakhs and one has given a claim of 25 lakhs. So the voting percentage would be 66% and 33%, 66.66 and 33.33. So it is basically on the basis of the voting percentage, and this percentage will define the resolutions are passed. So it is not one vote for one financial creditor. It is on the basis of their claim amount that the voting percentages will be decided. And also where there is a consortium loan, each financial creditor needs to file its independent claims, and the voting rights will be given independently to them. A related party of a corporate debtor will not have any representation or voting rights in the COC. Suppose the director has given loan to the company, even though he is qualified as a financial creditor, but he will not have any voting rights and he will not be a member of the COC. And in case a company is debt free, there are no financial creditors, then in that case, 18 largest operational creditors by their claim value will form the part of the COC, which will include 1 workman representative and 1 employee representative. In case there are less than 18 OCs, then all the OCs will form the COC. So basically, it is the financial creditors. If no financial creditors, then 18 operational creditors. And if there are less than 18 operational creditors, then whatever be the number of operational creditors, they will form the COC. Now, after forming of COC and after getting the resolution plan, after getting the information and taking control of the corporate debtor, the RP will constitute, will draft an information memorandum which will contain all the assets and liabilities of the corporate debtor, and thereafter he will invite resolution plans from the public in general by publishing Form G in newspapers. So resolution plans, as I told earlier, any person may submit a resolution plan if not barred by the provision of Section 29A. So a resolution plan can be submitted by anyone. It could be submitted by a consortium of persons. It could be submitted by a joint venture. It could be any combination which could submit a resolution plan. There is absolutely no bar. The resolution professionals are present to the committee of creditors for its approval such resolution plans which conform to the conditions referred to in subsection 2 of section 30. The committee of creditors may approve a resolution plan by a vote of not less than 66% of voting share of financial creditors after considering its feasibility and viability and such other requirements as may be specified. So a resolution plan is approved by 66% voting share of the members of the committee of creditors. If a plan does not get 66% votes, then the only option available is to send the corporate debtor for liquidation. Now, once the plan is approved by the committee of creditors by 66% voting share, then the plan is required to be placed before the adjudicating authority, that is NCLT. If the adjudicating authority approves the resolution plan, it becomes binding on the corporate debtor, its employees, members, creditors, guarantors, and all other stakeholders involved in the resolution plan, including statutory authorities. Now, this is very important provision. If a person has failed to give its claim and a resolution plan gets approved, the claim will be written off. The new management will not be responsible for that claim. Yesterday, the Finance Ministry has come out with a circular where they have specifically instructed the GST department to file their claims with the IRPs. What the GST department was doing till date, even after 5 years, more than 5 years, 6 years of IBC, the GST usually don't file their claims with the IRP. And once the resolution plans get approved, they start litigating the matter, saying that we have priority. They start harassing the new management by saying that the company, because under IBC, the company does not lose its existence. The company remains a going concern. So GST start creating a lot of hurdles. So yesterday, only the Finance Ministry has come out with a circular and has specifically stated that where the GST department has failed to file the claim and a resolution plan gets approved, the claim of GST department gets extinguished and they cannot harass the new management. So they have instructed the GST department to file the claim immediately as and when a company is admitted under CIRP proceedings without waiting for the consequences to happen. Now, in case the adjudicating authority rejects the resolution plan, so this is a check over the COC. There may be various stakeholders who may say that the resolution plan does not conform with the provisions of law applicable to India, or there are other deficiencies or the voting percentage or for various other reasons the resolution plan is not appropriate. The adjudicating authority has the power to reject the resolution plan. And in case the resolution plan is rejected, the company will go into liquidation. Now, this is the process. However, there is another window under section 30A, regulation 30A read with section 12A, wherein even during after admission of an application under section 7, 9 or 10 for CIRP, the CIRP proceedings could be withdrawn by the applicant who initiated the proceedings. So in case the matter gets settled after admission of the case under CIRP, the same could be withdrawn within a period of 30 days with the permission of adjudicating authority. And in cases where COC has been formed with approval of 90% voting share of COC members after constitution of COC. So the applicant may file the application for withdrawal of CIRP proceedings. However, in case the resolution plan does not get approved or no resolution plan is received or the approved resolution plan is rejected by NCLT, the corporate debtor will go into liquidation. And liquidation is similar to winding up, as we have been seeing under the provisions of Companies Act. The difference is that under the provisions of Companies Act, official liquidator used to be appointed by the Honorable High Court to take over the assets and liquidate the company. However, under IBC, the insolvency professional will be appointed as the liquidator, and the liquidation, he will perform the functions of the liquidator and liquidate the company under the provisions of IBC. The entire process, as we have seen in CIRP, is also given for the liquidation of the company. Various steps have been given, how the claims are to be invited and how the assets are to be liquidated after liquidation, how the assets will be distributed among different stakeholders, the secured creditors, the employees, the government dues, how the distribution has to take place. Section 52 and 53 deals with all these provisions. So I have not touched upon the liquidation in detail, because liquidation is a very long chapter in itself. So with this, the CIRP proceedings comes to an end. If there are any questions, you may ask.
Gautam, can you please stop the sharing so we can have people? Thank you, Gautam. It was really, you have enlightened us a lot about IBC, the complete processes that any of the corporate will be going under IBC in case of insolvency. Uh, they are boons also, they are cons also. We have to manage accordingly. And the idea behind the government has is to fasten up the basically recovery processes and let the corporates function properly in working. Now we are open for all the queries. Uh, any of the queries, if we have, you can please come up and unmute yourself and place the query. Okay. Till the time somebody asks, Gautam, can you please explain us what will happen, as you said during the moratorium period, the decrees will also get stopped. What will be the state of those decrees once the resolution plan is approved?
Once the resolution plan is approved, the resolution plan will tell every person who is claiming any amount from the corporate debtor has to file its claim. Even a person who is holding a decree needs to file his claim with the IRP or RP. So his claim will be dealt in the resolution plan. So once the resolution plan is approved, the decree holder will get the amount as proposed in the resolution plan.
Okay, so I understand if some of the degree holder is not able to reach the IRP or RP with the decree that has been approved, got from the court of law, then his rights will also be diminished. Like
Yes, because the resolution plan gives the rights of everyone. So there is generally a clause in the resolution plan that all the decrees shall be treated as null and void, or no amount will be paid to the decree holders, and only amount is being paid to the claimants, creditors who have filed their claims.
okay. One more thing that cropped up in my mind. So, if I am a decree holder for against any of the XYZ company which are going through this IBC process, so I am also a part of COC then?
No, only the financial creditors. You may be a decree holder in the capacity of a financial creditor if you are a bank or NBFC, or you have advanced any financial facilities or loans to the company. So your claim will be classified as financial debt. In
Okay.
that case, you will be a part of the COC. However, in case you have supplied some goods or services, or you have been in employment of the corporate debtor, then you are classified as an operational creditor. And operational creditors only come into the COC in case there are no financial creditors.
We are still open for any of the queries. Thank you, Chinmay sir. If any of the query, please let us know. And we will be keeping a series of webinars on the topic of IBC on a month-to-month basis on different issues related to IBC.
Thank you.
I hope there is no query left. You have already explained very, very well about this topic. Thank you, Shivam sir.
Correct. Okay.
Now, I think we are at the end of the session now. I thank all the participants to give their time for the webinar, and it's really encouraging for us. Uh, and we thank you very much for coming to the webinar, and we'll keep
Thank you.
posting such kind of webinars for information. Thank you very much. Thank you, Gautam.
Okay. Thank you.